Hello everyone and welcome to today's webinar. Hope you're all having a fantastic week so far. For those of you who don't know me, my name is Kate Chalker and I'm an associate with the firm based in our Sydney office. Also on the screen you'll see Adrian Bailey, who will be presenting our webinar today. And Adrian is the managing principal of the firm, also based down here in Sydney. And in today's webinar, Adrian will be teaching us all about testamentary trusts, how they operate, and he'll be taking us through a couple of cases which examine just how effective they are in terms of general asset protection and also protecting against family law claims. So before I hand over to Adrian, I'll just run through some basic housekeeping just in case there is anybody new to the platform. So firstly, if you would like to download a copy of the PowerPoint slides from the webinar, you can do that by clicking on the Files button on the right-hand side of the screen, and you'll be able to download a PDF version of those from there. If you do have any questions which come to mind during the webinar, please feel free to submit those. You just need to click on the chat button again on the right-hand side of the screen, and you'll be able to type in your question there. I'll be keeping an eye on those questions as they come in, and I'll interrupt Adrian at an appropriate time to put those questions to him. Also, just a reminder that today's webinar is being recorded and it will later be uploaded to both our website and our YouTube channel. So if you do need to duck out at any time, you will be able to revisit the webinar at a later stage, but also just keep that in mind when you are submitting your questions. All right, so I think that's all the housekeeping I need to get through. So I will hand over to Adrian to get started on today's topic.
Thank you, Kate, and welcome to everybody to the webinar. I think it's pretty safe to say that the three things here that we've got listed are pretty common client objectives in relation to their estate plan. First of all, making sure that they're adequately dealt with their death, their personally held assets, so making sure that they've got an effective estate plan and their assets go where they want them to. Ensuring that they're protected for future generations, and that's really, I think, the core part of a client's objectives on them most often when we're dealing with them with an estate plan. And the last one, maximum tax effectiveness and flexibility. Probably more a concern of advisors than the end client in many occasions, but it is often a client objective to make sure that, one, whatever they've left behind is protected for the future generations, and there's also flexibility in terms of tax moving forward. So hence why very often when we're discussing things with clients in terms of their estate plan, we very quickly turn to discussing testamentary trusts. And of course, the question then is, well, do they work? Are they effective for what you're looking to do? And the areas that we're going to cover today is having a look at them and trusts from a general asset protection perspective, and having a consideration of some of the core points or key positions that we might have in our testamentary trusts and what we need to think about when we're talking to clients about them. The thorny issue of family law claims, recurrent, and very often I find is the most concerning matter for the clients, that they want to make sure that whatever they're leaving behind doesn't end up in the hands of ex-spouses, ex-partners. So very often a lot of the conversation will revolve around that. Even when they have adult children in happy relationships, it always seems to be something that's ticking away in the back of the client's mind. We're going to briefly examine taxation of testamentary trusts, more just a refresher on what I call recent changes, but probably aren't that recent, in relation to some tightening of the rules there, and just cap it off with a bit of a discussion on our Bloodline will trust and how it works and why we developed it. So, kicking off the first part, testamentary trusts and general asset protection, very similar considerations where we have what you would consider to be a fully discretionary trust or a version of that, which is the form of our testamentary trust, and our testamentary trust can take many versions. But for the most part, what we'd be looking to implement would be something like a fully discretionary testamentary trust, because that's going to give us the most flexibility. going to give us the most powers for the trustee moving forward. And so having a think about that, generally asset protection and trusts, and without knowing whether I'm just preaching to the converted here in terms of level of knowledge, it's always worthwhile recapping. The rationale really behind trusts being used a lot for asset protection reasons in Australia is that we can control the assets and we can benefit from them, but we have no ownership interest in relation to the trust interests. And our rights as beneficiaries are quite limited. They're limited to effectively the right to be considered. So the trustee has to consider us in distributions of the trust, and the right to due administration. So the trustee has to follow the rules of the trust and the rules of trust law generally. Aside from that, very limited rights as a discretionary beneficiary of a trust, whether it be a testamentary trust or an inter vivos trust. Trustee, they don't hold legal ownership in relation to the property. They hold it for the benefit of the beneficiaries. And in other roles, which we'll go through, such as principal or appointor, again, no ownership interest. So as a very starting point, very good idea to have a discretionary form of testamentary trust in that we're providing that asset protection for claims outside of the family law claim. So if our clients' children are in business, or if they're doctors or lawyers or accountants and we've got concerns about asset protection, then very often we'll start talking about testamentary trusts from a general asset protection perspective. In terms of the trusteeship, this is very often something that we'll spend a lot of time talking to clients about, and they'll spend a lot of time considering who this person should be. And when doing an estate plan, we need to obviously do a bit of what-ifing. So what if that person's not around? Who takes that role? And so usually you've got to have a double consideration there as to who would take the role of trustee originally, and who would take the role moving forward if that person's not available or retires. And so very often that's what clients can struggle with in terms of deciding who this person is. First of all, we need to decide whether we want in our testamentary trust document an individual trustee or corporate trustees. Most will documents that I see, whether we're drafting them or other lawyers have drafted them, will have an individual acting as trustee in the first instance. And the practical reason behind that is if we have a company acting as trustee in a testamentary trust, it's not actually going to do anything until the person passes away. So we would have our annual review fee with ASIC, and although that's not a lot of money, clients might look at that and think, well, I'm not planning on dying anytime soon. I don't want to set up a company just to have it sit there as the potential trustee of a testamentary trust, particularly where we have a mechanism in there that trustee can be changed to a company once the individual takes trusteeship. So that aside, whether we have individuals or whether we have a corporate, we need to think about we should think about using somebody else along with the children as co-trustees of the trust. And very often we'll have a discussion with the clients and they'll decide that they're looking to have what you would consider to be an independent co-trustee, acting as trustee of the testamentary trust together with the relevant child. The rationale behind that it tends to be more from protection from a family law perspective, and we'll have a look at that when we examine that a bit later. But the other benefit of it is that usually if it's an independent person, very often they're a professional, so very often an accountant, and all professionals have to abide by their code of ethics. As you all well know, the recent TPB changes, which thankfully have been delayed, further impose more obligations on you as a professional. But if it is somebody like an accountant, they've got knowledge of financial affairs, they know not to make rash or silly decisions often. And so very often a lot of the conversation will turn to consideration about whether it should be somebody like an accountant as this independent person. If there's not somebody like that in the stable, it can be family members, can be other siblings, although then that leads to a discussion of whether that's a good idea in terms of whether the siblings get on and those sorts of things. But it is something very often that you have somebody who you'd call independent in that role. If we're putting that person in and they're not family members and they're someone a bit distant, very often we'll limit their decision making to what you'd consider to be the major decisions. So decisions relating to dealing with trust assets, changing trustees, terminating the trust, all have to get the tick of approval from this professional independent co-trustee. Day-to-day decisions continue to get made by what you consider to be the main trustee. So you can have a bit of flexibility there, but as I said, the main driving force often behind having this person there is consideration of a family law perspective. It's also pretty good from a stability perspective, of course, and to have somebody there, what I often say to clients, riding shotgun with the child to make sure nothing silly happens, because in the absence, realistically, of having somebody else there, if the child decides to, they could terminate the trust and take all of the assets out, which defeats the purpose of setting it up in the first place. As to the person, again, I often say to clients, it should be somebody with a bit of common sense and a bit of backbone. Common sense enough to know what they don't know, so they go and get advice, and a bit of backbone and the ability to say, no, I'm sorry, Kate, you can't go and get that Lamborghini. However, you can have a Tesla if you want. So something along those lines is always good to have that independent person there. If our trust deed has the role of principal or appointor within it, that's usually the role that has the ability to power, appoint, or remove the trustee. So that's really what I often consider to be the controlling person or persons behind the trust. Because if I can change the trustee, then I can appoint whatever trustee that I want to it. And certainly there's been plenty of case law over the years about people fighting over that role and whether the appointment was legitimate, and because they've used that position in order to appoint a different trustee to the existing trustee to perhaps advance their own interests. In terms of that from an asset protection perspective, it's important to remember that this role is what's called a personal right. In terms of property law and rights, we have what are called personal rights and we have property rights. So a property right, for example, would be your right in relation to your main residence. A personal right is something like the role of principal or appointer. Another example of one would be the right to vote or the right to give a power of attorney. That's a personal right. So if you become bankrupt, and again, this is considering the general asset protection perspective, that right is not something that the trustee in bankruptcy can take. It doesn't vest in the trustee in bankruptcy. I'm getting a bit old now, but the most recent decision on that where the trustee has had a go at it is Burton, Wiley and Burton back in '94, which confirmed that personal rights don't vest in the trustee in bankruptcy. So from an asset protection perspective, we can have somebody in that role who ends up bankrupt. Of course, it's always a consideration as to whether they should be removed from that role in case there's just some argument over it and we don't have an argument. But again, thinking about the family law perspective, it's also obviously if we have that role within the deed, it's a good idea to have that independent person in there. So it can't be said, and I'm going to keep picking on you, Kate, because your name's foremost in my mind. It can't be said that, well, that's Kate's trust. She has the role of principal or appointer and she can change the trustee. So that's really her property. So on to what we'll talk about probably the most in this presentation, protection against family law claims. So still very, very strong protection against a family law claim if we get our documents right. And by saying that, it's effectively making sure that we have what you consider to be a discretionary testamentary trust and the right people or persons in control positions. Very wide, what you consider to be trust busting powers within the Family Law Act. So they can either treat assets as either property of the marriage or as a financial resource. They can set aside transactions relating to trusts under 106B. They have the power to declare a trust a sham if it's clear that it just never existed and it's all a sham to try and get around the family law. And if they decide that that the property is the property in the trust is property of the marriage, or then they have the power to alter the ownership interests of a third party, including trustees holding assets on trust and the assets of those trusts under 8AA of the Family Law Act. Should point out for our attendees in Western Australia, you continue to march to the beat of your own drum in respect to family law and have your own standalone Family Law Act as opposed to the Federal Act, which all of the other states and territories have adopted, but very similar powers in that Act. So the same sorts of considerations there. terms of what again, we shouldn't say it's recent anymore because it's got some history now, but the case that really kind of flipped on its head in terms of thinking about trusts and family law was Kennan and Spry. And you may or you may not have been through or sat through multiple presentations on what it is, so I'll only briefly touch on it. But in essence, it's a case involving a trust. Dr. Spry was a tax barrister. They got married in 1978, had 4 daughters. He had a very strange trust in that it was initially, there was no trust deed. It was all effectively orally. He was the settlor and trustee, which again is a little bit strange if we think about the revocable trust provisions within the Income Tax Act, but he's a tax barrister. Surely he knew better and didn't think they applied. And he had the power to vary the terms of the trust. During the relationship and during the marriage, he's transferred substantial assets from his personal name to the trust. So although a trust is involved in this case, to me, a lot of it is things that really should have been part of the family law breakup anyway. But because it went so far and it went all the way to the High Court, and then there were some other proceedings after that, principally because of the personalities involved, that we've got effectively some new case law out of it because they were forced to examine it because it just kept getting appealed and continuing on. So the relationship hit some issues. It's clear that they're going to break up. Dr. Spry transfers assets out of that trust into 4 trusts that he's established for his daughter. He's not a beneficiary, wife's not a beneficiary, or he excludes them, and daughters are trustees. Court, having a look at that, overturned that transaction and brought everything back to the original trust because it was clear that that transaction was only done to attempt to defeat a family law claim. So even if those trusts were found to be outside of the relationship or not able to be accessed by the family court, they said, well, no, bring it back to the original trust because you've only done that. The relationship was already in trouble. You've only done that to try and hide assets or protect assets. When they examined the terms of the trust, they decided that the interest of Dr. Spry as trustee, coupled with his power to appoint trust assets to Mrs. Spry, fell within the definition of property of parties to the marriage. So that's where we have our first sort of difference from what was accepted law at that stage. Justice Kiefel, or High Court, the Chief Judge, as she subsequently came, she was only one of the judges then. I shouldn't say only, it's a pretty lofty position, Justice of the High Court. Justice Kiefel also made some comments that Mrs. Spry's right to due administration of the trust, so if you remember I was talking about what rights beneficiaries have, was also property of the parties to the marriage. So it could have been accessed that way. So, of course, after Kennan and Spry, family lawyers got very excited and thought, various publications out there saying, well, that's it. That's the end of trust for asset protection. Testamentary trusts, no point having them because we can attack them under a family law claim. But what we have seen since then, and really quite rightly so, is that different facts lead to different outcomes. Kennan and Spry was a bad case to run. Cleary only ever did these things to assets that were part of the relationship to try and hide them from his wife. So some fascinating other things that happened in that case after the High Court, but I'll leave you, if you want to go and research that, in terms of him applying to get admitted again as a barrister, because by the time this had all gone through, he was no longer a barrister, and some of his actions in some of the defamatory letters he sent to the judges of the High Court, as well as the enforcement proceedings where he did threaten to burn all of the money. He converted all the assets to cash and he threatened to burn all the money rather than give it to his wife. So obviously it continued on after the High Court, as we all know family law matters get a bit messy. So different facts lead to different outcomes. Proper structuring and administration is essential. And so we can have a look at that in the cases. So one of the first cases post Kennan and Spry to examine trusts, and these were inter vivos trusts, so trusts set up during the life of the client, was Essex and Essex. And so with this, we had 2 trusts with property gifted by the husband's mother. And so one was set up for husband, one was set up for his brother. In terms of establishing the structure, a stated objective of the gift was to protect mum's assets from James. This was the husband's wife. So She literally said, we're establishing these trusts. I'm not going to give the assets to you because I'm concerned about your wife. I'm going to give them to the trust. He was an income beneficiary of the trust. He was neither a trustee director. He wasn't the appointor. And in this, very quickly, family court said, well, he has no control over that trust. He's a beneficiary. Those assets aren't assets of the relationship. And of course, you'd think a sensible decision, particularly considering where the assets have come from. I should say in these decisions, very often the next step is for the court to declare that they're a financial resource. So what that means is that it says, well, we can't access these assets. This is not what the court says. This is the way I explain it. We can't access these assets. However, we recognise you're going to get something out of them at some stage. So we'll adjust the other assets differently. And we might give the husband or the wife, depending on which side of the table the trusts sit, more of those assets. But in talking to clients about this, it's always more about making sure that what we're leaving them, whether it's during their life or afterwards, is protected. So we're protecting that core capital. A more recent one, a Victorian case, Bernard and Bernard. And so this one, it examines testamentary trusts, and it's only in the last couple of years, so it is relatively recent in this world. And so with this, we had a husband and wife who split after 27 years of marriage. They had 2 children in their early 20s. 3 years before their breakup, the husband's father died. And I always, when I read those facts, I was kind of wondering, I wonder whether the wealth coming in was the impetus for this breakup, considering it was only 3 years later. So under the father's will, 2 testamentary trusts were created for the husband and the sister. And the father's estate, which in total was 3.8 million, was distributed to the testamentary trusts. Now, in terms of their structure, the husband was, and we're just looking at the one trust that was subject to the family law claim. The husband was what was called the primary beneficiary. The wife and children were general beneficiaries. There was an independent appointor, and the sister was the trustee. The trust on the other side, so what you call the sister's trust, I guess, was a mirror image. So she was the primary beneficiary, spouse and children, general beneficiaries, independent appointer. The husband was the trustee. That was the structure. It was very much what you consider to be a standard discretionary trust in the form of testamentary trust. What they then went on to do in the 3-year period in between the assets coming down and the breakup was they ran a property development in partnership of the 2 trusts. All the income was accumulated and the husband was employed on a salary from the partnership of trusts. So ignoring the sort of general prohibition about partners drawing a salary, I guess the partner is the trust, but with that, that's what they did with the money. The wife ran a number of arguments, or her lawyers did, and one of that was, okay, well, we accept that there's no legal control of this trust, but as it was, in essence, a mirror image of the other trust, he had the real control. It's kind of like saying, oh yeah, Judge, we know what's going on here. He's pretending he's not in control of this trust when it's really him. And the sister just signs off on what he does and vice versa. The other argument they ran was that due to it being a partnership, they had rights and obligations to each other, and that he exercised control via that under partnership law or partnership principles. It was a sham. The sort of like last recourse of your failing legal argument is to say, well, this is a sham. The trust never existed. They're not legally implemented. That didn't win. And the final one being, well, Kennan and Spry, Chief Justice Kiefel, as she is now, Kiefel, said the wife has right to due administration as property of the marriage. She has rights as a beneficiary. That makes that property of the relationship. So, in dismissing the argument, what the court found was that the wife, okay, they accepted she had the right to due administration. So, consistent with Kennan and Spry, she was a beneficiary of the trust. But they found that right is really hard to value. How do you put a value on that right? And so we accept that it's property of the relationship, but we just can't put a value on it. And so we're not going to adjust any assets within the trust because of it. The husband and the sister have been very meticulous in their documents and how they made decisions and documenting how those decisions were made and how they were each acting independently of each other as trustee. And this comes back to mentioning about record keeping and making sure that we maintain our structure properly. And there'd be no blurring of the lines where, in essence, the husband, as you sometimes see, husband's operating the bank account for the other trust and so forth. He also never acted as the assets were his own, and it clearly wasn't a sham. So Bernard and Bernard, good recent case law to confirm that if we have our structure right, that testamentary trusts are still strong protection from a family law claim. Our lessons from those cases, and there's lots of other cases out there, but those are two that we just wanted to raise. Control of the trust, the testamentary trust, is crucial. It comes back to, should the person who we're in essence nominating this trust for, should they even be in control? Should it be somebody else as trustee? If they are there, do we need an independent person there as co-trustee? Yes. And so that's where that really core conversation comes in with client about trusteeship and the appointor role if we have that. That's really crucial from a family law concern. Record keeping records of what we're doing. For this, if we have an independent person there or a different trustee, then the person who's, if I could use the term trusted, is making sure that they keep records of their decisions and making sure that they've got the ability to stand up in court and say, it wasn't just Kate telling me what to do. I did what I did. This is the reason I made that decision, so that you've got somebody there who can give that evidence. So structuring and advice are crucial. Protection can still be achieved from the family law. We do have, of course, our Bloodline Will Trust, which has some further additional protective features, and I'll touch on that towards the end of the presentation. Oh, no, I'll touch on it now. I forgot that it was straight up. So, history of the Bloodline Will Trust. It was developed by our firm in the early 1990s and was a response to concerns by farming clients about the impact of divorce on the children on the family business. So the genesis was really in North Queensland in the Innisfail area, which, if you know, is a big cane farming area, predominantly Italian migrants at that stage, along with some Indian migrants. And their concerns were, we're having lots of sons or lots of daughters. We want to make sure that the farm stays in their hands if we pass away. So that's where the idea came from. We've held the trademark since the 90s. Of course, there's other versions of similar trusts that do similar things out there, because lawyers being lawyers, we steal each other's documents, or other lawyers steal ours. And so with that, they can't call it Bloodline Trust because we hold the trademark. So how does it work? We have a difference between what beneficiaries, and that we have a definition called primary beneficiaries. And often that is going to be focused off a particular person and go down their direct descendants. So Kate's children, grandchildren, great-grandchildren. We can build in mechanisms that allow for adopted children, stepchildren to be included. Of course, that's a discussion with the clients about how comfortable they are with that. But the first idea being that capital can only ever go to these beneficiaries. And so with that, from a family law perspective, the spouse could never be a beneficiary of this trust. The spouse could never benefit in a capital sense from the trust. The other beneficiaries of the trust have rights. Future beneficiaries have rights. And those rights shouldn't be trampled on by the family court in relation to distributions of capital or accessing the capital of the trust. We will also then often have a wider class of income beneficiaries. And again, that's conversations with the client about how comfortable they are about that, where for tax reasons, of course, we've got the flexibility to distribute income. So the whole idea being that we're building a wall in relation to the capital that's coming down from mum and dad, and making sure that that stays within the bloodline and the descendants. So if on our diagram, if son and wife go through a divorce, son would be the capital beneficiary, wife would not be. That's our first line of argument. Of course, then we've got arguments such as Bernard and Bernard to show, depending on how our trust is structured, to show why it's not property of the relationship. And so that's what the Bloodline Trust is all about. Just a very brief discussion on structuring testamentary trusts. And so in this example here, we've got 3 children. So the first discussion in terms of the structure of the testamentary trust with the clients will be, should we have one testamentary trust that all 3 children are in control of and benefit from? Or should we have 3 trusts and we divide our estate in this example, because we've got 3 children, equally amongst those 3 trusts? Positives and negatives of both approach. For the first approach, where we're just having the one trust, it does provide more protection from a family law claim down the future, because it's clear that this trust is not just for Kate. It's for Kate and her sister and her brother and their children and grandchildren and so forth. And so it takes away a lot of the arguments in relation to family law of the sort of alter ego type argument of the trust. The negative of that is 30 or 40 years after mum and dad die, I can bet you that Kate and her brothers and sisters, in our imaginary example, are not as friendly as they were 30 or 40 years before, and have their own lives and are doing their own thing. So there is often, and you often see it in probably the 3rd generation of a trust, that's when they start looking to break up the trust, in my experience. So great from protection, not great for flexibility, and thinking about a trust that might last for 80 years, 80, after the client dies, that we want to have some flexibility there. So the alternative being that we split everything into 3, and each child gets, in a notional sense, their own trust. And so I say notional on the basis of, if we're structuring it properly, they don't have complete control, and so they're going to benefit from this trust, but they don't have that control aspect from a family law perspective. So the disadvantage, of course, weaker from a family law perspective. We can deal with that by looking at the trusteeship and the principle of the appointor role. The main advantage is that flexibility. 30, 40 years down the track, we don't have to agree with our siblings or our siblings' kids, if our siblings have died, about what we're doing with our assets. So I think most times when you discuss this with clients, unless they've got really young kids at that stage when you're doing this, they'll often end up with having a separate trust for each child. We often review our trust deeds, of course, based on changes in law or changes in case law. In Kennan and Spry, a couple of the major modifications we made to the deed is that if a beneficiary, what we slightly call, takes an attacking position against the trustee, so if they make a claim against the trustee, they're automatically excluded as a beneficiary. And it's also specified that a beneficiary's right to due administration does not form part of the trust fund. The second part is really an untested area, in that, we're putting that in there in a response to Kiefel's comments, but as to whether it would be effective or not, because it does go against, trust law to say that they have a right to due administration, and that extended under the judgment to say it forms part of the trust fund. Just putting that in there, just so that we've got it in there as an arguable position there, and on the basis of better have it there than not. Moving on to taxation of testamentary trusts. So a testamentary trust created under a will or a codicil, we have a look at 102 AG 2 subsection A in terms of the treatment of that income. So as we probably all know, Division 6AA imposes maximum or punitive rates of tax on minors that receive distributions from trusts. There's some exclusions to that rule. And one of those exclusions is where the distribution of income is coming from a testamentary trust. So if we meet the 102 AGGA, then we have what's called accepted trust income. The obligations or the requirements of accepted trust income is it's income of a trust resulting from a will or codicil. So that's a testamentary trust, which is derived by the trustee from the investment of any property that devolved for the benefit of the beneficiary from the estate of a deceased person, and is derived by the trustee from the investment of any property. So again, actually I'll go into it on the next slide. So if we meet those requirements and we've distributed income to a minor from the testamentary trust, it's accepted trust income. They're taxed as an adult, and so we can, in essence, have up to the tax rate currently of tax-free income in that year distributed to children or grandchildren under the age of 18. Of course, in order to get that result, we've got to have a trust that's created under a will or codicil. It's got to have assets in it, and we've got to have beneficiaries under 18 at that time. But it is a tax advantage to these forms of trusts. There's been some tightening up in relation to accepted trust income. And so it is now specifically specified that it's restricted to assets, income from assets that either pass to the testamentary trust via wills, or the growth of those assets, or substituted assets. So up until that time, it was arguable that we could, for example, have a testamentary trust that could borrow to acquire some assets. Those assets, the income from those assets would then be accepted trust income, and we could distribute from that to our children and receive concessional tax treatment. And there were a few cases, like First's case, that examined that and confirmed that you can actually do that. The government obviously thought there was too many people doing this and the potential for mischief, so they tightened that up. So in essence, what that means is that it's really only the assets or the growth or the substitution from the will that we get accepted trust income, which also then leads to consideration if we're adding assets later on, which you can do to a testamentary trust after somebody's passed away and it's active, those assets won't get the same tax treatment. So we'll effectively have to run two sets of books, one dealing with the income from that will be accepted trust income from assets that come under the will or their substituted assets, and one from what you call the new assets. So it may be a consideration as to whether we put it into the trust or not from a tax perspective. Just makes things a little bit trickier for the clients and a little bit messier. Dealing with testamentary trusts these days, we need to think about what the nature of the assets that are going into them, in consideration of either land tax surcharges. Shouldn't be a duty surcharge because it's dealt with under the will. But depending on what the asset is going in, and land tax generally, we need to think about it if we're putting things in like a family home to a testamentary trust. But very often a testamentary trust won't exclude foreign beneficiaries for flexibility reasons. And so if we're going to put some residential property into a testamentary trust via the will, at that time, do we vary it to exclude that so we don't get a land tax surcharge? So again, consideration moving forward once we're administering the estate. So as we've seen, properly drafted trust continues to offer significant asset protection benefits for those trust law reasons and asset protection reasons. Family court can't budge through a testamentary trust will that's properly set up and properly administered, and really the same applies to a testamentary trust that's not a bloodline trust, as we can see in Bernard and Bernard. And there are continued tax savings, which, a little bit more complicated than they used to be, but they're still there. And so, as I said, if we have the ability to distribute income to a minor, it's a pretty good result for the clients at that stage. Kate, any questions?
Yes, I do have 3 questions for you at the moment. So everybody else, if you do have any more questions, feel free to send them through now. But the first one that we have is, how do you go about removing an appointor of a trust?
So the first step would be to have a look at the deed and see what the mechanism there, if at all. Very often, there's no power to remove an appointor. It's something that they have to resign from or appoint somebody else in their stead. Some deeds, you have this concept of the guardian or the protector, who is kind of like this overarching person that could remove an appointer. But 90%, 95% of deeds, I'd say, you can't remove an appointer, they've got to resign. You could. And if the concern is, well, what if I appoint someone and I want to change that later? So, for example, this independent person, you can build in mechanisms there that you can substitute them. But depending on what the deed says, it's very likely you can't just remove them.
All right, thank you. The next question is, what is the tax rate applicable to undistributed trust profit or income in a testamentary trust?
So it's the same as an inter vivos trust. It's a top marginal tax rate if it's accumulated.
And then another similar question. How are the earnings from an amount held in trust as a result of a will, but not a testamentary trust, taxed? So I think that's referring to a gift from a testator to an inter vivos trust. How would that trust income be taxed?
Yeah, so if it's a gift to an existing inter vivos trust from a will, that is not a trust that has been created by will or codicil, so it wouldn't be accepted trust income, and we're back to our normal trust taxation rules in relation to that.
Just had another one come in, confirming that if foreign persons aren't excluded from the testamentary trust, that you can amend at a later stage, for example, before the trust is established following death.
Usually, of course, the trust has to have the power to be varied, and most well-written testamentary trusts will have that power. But as long as we've got the power to vary it, we can amend it at a later stage to exclude beneficiaries and then not have to worry about the surcharge if it is residential property that ends up. And I wouldn't say it's a common step, would you, Kate, but it's something that is quite often done as part of the administration of the estate. You have a look at what assets are potentially passing, and then you make that change.
I've just had one more come through from Wayne with quite a few numbers and specifics. So I'm thinking that if you're all right with that, Adrian, we might look at that separately and come back to you, Wayne, on that question.
Are you suggesting numbers is not my game?
Don't want to put you on the spot with that.
Fair enough. No, I agree. Yeah, we'll email you separately about that, Wayne.
I think I just had one more. So if a distribution is declared to a minor, is there a reimbursement problem if the cash is distributed to the minor's parents and used by the parents for the minor's living expenses, school fees, etc.?
Not in that circumstance, because you are in essence applying it for the benefit of the child. So if you're paying their school fees, living expenses, then I would say you quite legitimately there's no longer an entitlement there because you've actually applied it for their benefit. But having said that, ordinary family commercial dealing in that regard, I don't have any issues with 100A in respect of those sorts of distributions and payments.
Okay, I don't think there's any more questions. So if anybody else has any questions come to mind after the presentation, feel free to contact Adrian or myself with those. But I think we will wrap up there. I'll just let you know that there will be a feedback email that will be circulated later today. And we would be grateful if you could take just a couple of minutes to fill that out, particularly if there are any topics that you would like to hear from us about in the future. We always take those on board, and they often decide the topics of our webinars. So yeah, if you could keep an eye out for that email and complete that at your leisure, that would be much appreciated. But otherwise, thank you all for attending and hope you enjoy the rest of your day.
Thanks, everybody.